After being president of Zambia for 7 years, former President Edgar Lungu's eligibility to contest another election is yet again contested. Earlier today, we heard a ruling by the court, and this ruling was on whether or not another petition should be heard on the eligibility of President Edgar Lungu to contest the presidency of this country one more time. This has sparked debate, with some people in the divide arguing that he's eligible to contest and he has contested before, while another says that the law cannot be applied retrospectively, and because the constitution was in place that made it impossible for a person to contest the presidency more than twice, and he can't stand anymore. This is what is in contest. Earlier today, a ruling was made, and on this edition of This Day, I sat down with the lawyer of former President Edgar Lungu, Makebi Zulu. I was asking him what this means for them, why their supporters were not there, and how they will move forward. Welcome to This Day. My name is Dingindaba Jonah Buyoya. Mr. Zulu, thank you so much for joining us on this edition of This Day. And we understand that you are very busy, especially in this specific period, a lot of things going on. And that's the reason why we're having this conversation, to talk about some of the developments in relation to your political party, but also some of your clients. And I want to start off, first of all, from a very general point of view. I'd like to make reference to a recent briefing that was held by the Minister of Home Affairs, who advised, or should I actually say instructed, members of the public to stay away from, proceedings at the Supreme Court, involving former President Edgar Lungu, and as was seen today, had the instruction of several police officers to be present there, stopping any citizens that had intentions of going there to offer support to former President Edgar Lungu. What do you make of this? And do you think that the minister is justified?
I think that's sheer lawlessness. We are degenerating into a full-blown police state. The question that should be asked to Mr. Jack Mwimbu, the Honorable Minister of Home Affairs and Internal Security, is how much did it cost the state today alone to police a court hearing that lasted for 30 minutes, not a hearing, a ruling for that matter, that lasted for 30 minutes. How much did it cost us as taxpayers? Last time the matter came up was for hearing of the arguments. And we saw people that came through, people that are sympathizers of the former president. There were an extent of 3,000 and nothing happened. There was no commotion, there was nothing. They were very peaceful. They did not disturb the flow of traffic. They did not disturb the public. They just came solidarity. Those that could come into the courtroom came into the courtroom, and they observed the proceedings peacefully and left. Perhaps it is the euphoria around President Edgar Lungu that seems to be a threat to this particular government, because there was no need and no justification whatsoever to stop the people from gathering. The reasoning that was given by Honorable Jack Mwimbu was that the last time such a thing happened, there was a shooting of someone, and that is some time back when a prosecutor was shot, as he stated himself. Now, that was the time when President Hakainde Hichilema appeared before the police. He appeared with a crowd of people. There are those that sympathize with him, that came, that attended to whatever was going on at that particular time. Nobody stopped him. And in this time and age, with our nascent, well, it can no longer be nascent, it's a developing democracy that we are in, we expected much better from themselves, because policing as it were, is intended to make sure that there's law and order at any particular time. But since we have the statement from the IJ himself to say that the other side, the UPND cadres, are always ready to attack the PF cadres or those that are sympathizing with the president. Perhaps from that point of view, we would understand. But then the idea would not be to stop members of the public from coming to the Supreme Court or indeed to the Constitutional Court or to any court for that matter, but to stop those that are trying to break the peace that is being enjoyed by those that are expressing themselves, those that are assembling, those that are attending public court matters, which is open at any given stage. In any case, we also wonder, why would Jack Mwimbu want to deal with possibly what should be administrative issue of the judiciary? If the judiciary does not want people to come, they will say so. That matter is a matter of public interest. The doors are kept open for a reason. That means any person can walk in and walk out. The gates are supposed to be open for any person to be able to walk in and walk out. It's what we have created for ourselves, to be a fountain of justice. It's not a place where we say only a selected few will go there. Justice must be seen to be done. Not just seen to be done by persons that are involved in the matter. Even the public must be able to see, sit and observe, and should be able to know that, okay, the right thing is being done. There's nothing to hide. Court proceedings are not a cult for you to be stopping people from attending. So that was uncalled for, undemocratic, lawlessness, and rule of man, and not the rule of law, because there's no law that forbids any person from attending court processes. And they shouldn't have done that in the first place.
There's two ways that I'm going to ask my next question, and I'll start with the first bit, and it's that it is true that, there was a time when, in fact, it was two different people that were shot. There was a prosecutor and one other was a supporter of the United Party for National Development at those very Supreme Court grounds. Isn't it wisdom to learn from events that have happened in the past and take decisive action to avert the possibility of any such further occurrence in the future? Because the reality is that sometimes it does get quite unruly when there's such gatherings, and it's better to be safe than sorry. Don't you think that's wise reasoning?
The reasoning is wise only to the extent that the two examples that you've referred to UPND cadres and not the PF cadres or any sympathizer for that matter. So there has been no justification in the recent past for stopping people from going to court. Because today, the ones that were disturbing the smooth flow of traffic were the police. Every person that was coming into the court premises, including judges and all court users, were being asked what they were coming to court to do. Any person can walk in, and other matters were being disturbed in the process. At the magistrate's court, we had the magistrate being inconvenienced from getting in, being asked to produce their IDs. Well, not everyone moves on with an ID. If you do, it may not be able to say you're a judge or a lawyer for that matter. But then the inconvenience was too enormous. It was unnecessary. It was highly unnecessary and should not have been done that way.
Now, the other side of this debate is, other people asking, and I'm curious to find out, perhaps you may have a better understanding of the essence of these gatherings outside of court, these huge crowds that go there, just standing there and singing and all that. And I acknowledge they have the right to assembly. But is this necessary in modern practice of democracy, in modern practice of politics, to have all this unproductivity, even on the opposite end? Today we complain that the police were blocking traffic, but if the cadres were there, they too would have been doing the exact same thing.
Well, It depends on what you mean, Buyaya, by what you mean by modern democracy. When democracy is about people and people exercising their freedoms, which includes freedom of expression, freedom to assemble, all those freedoms must be practiced in a democracy. So if I am discontented and my way of showing my discontentment is marching, I should be able to march unhindered. If my being dissatisfied with particular happenings, events, or indeed statements, I should be able to express myself either by way of speaking. If I want to go to court, I should be able to go to court and sue. All those are freedoms that are supposed to be exercised in a democracy. So if you ask me whether or not it is necessary, that is a very individualistic decision that has to be made. Each and every person, if 2,000 people on their own decide we're going to do this, let them do that. That is what a democracy is. People must be able to express themselves. So we can't really limit to say, you can only express yourself in this way and not the other way. What was eminent in this particular case should have been taught to say, okay, there's imminent danger that there may be this particular event, in which case, even then, the job of the police is to deter the offenders, those that are likely to breach the peace, not those that are peaceful. But it seems like Honorable Jack Mwimbo's view is that, okay, because there are some people who are likely to be rowdy, you who are peaceful should not show up. That is not how we do our policing. Our policing should be done to the extent that it is only the offenders that are dealt with, those that are breaching the peace that are dealt with, not those that are peaceful. So it defies all logic that we should even be having such a discussion in this time and age when we know that the job of the police is to keep the order, keep the peace, and not to pursue the peaceful. So in this case, we are getting into, or we are now a full-blown police state. Everything is dependent and is being controlled by the police.
Are we making any progress, Mr. Zulu, with regards law enforcement through the Zambia Police Service? Because I know that this is not the first time that the Zambia Police Service is coming under fire, and a lot of complaints from members of society that they're not managing peace well, they're not managing themselves well, and they're infringing on the rights of citizens. It's almost like a broken record. And unfortunately, it is successive governments, even governments that you have been a part of. So are we making any progress with this, with regards to the Zambia Police Service at all?
See, if you look at the history of this country, the police are at the worst position that they've ever been in the history of this country. In terms of brutality, in terms of everything that they've been doing. We've heard of abductions, people being taken in the bush, people being taken out of police cells at 23 hours, being tortured. We are hearing of those things now. The last time those things were being heard was possibly during the Kaunda days. In between, it's been now we have this government, and those things are coming, and they're much more rife. And it appears as though those things are pretty much normal because they're being conducted by the state. But it shouldn't be that way. It shouldn't be that way. We can't justify it in any way. We can't say because it has been happening before, so it's okay for it to continue happening. It has to come to a stop. And now was supposed to be the time when we should have been seeing better, as we were promised better. There's always this lip service of rule of law, but do we see it? We don't see it. Even when there are pronouncements that are being made that don't arrest anyone until and unless you investigate and have finished investigations. What do? We see people being held. Why is this person being held? To assist with investigations. It's not the job of an accused person or a suspect to assist the police with investigations. They're supposed to investigate, conclude investigations, then arrest. Even when they arrest, they are supposed to put someone, give someone police bond, or indeed avail that person within 24 hours before a court of law, where that person can apply for bail. Do we see that happening? We've seen people being detained for a period longer than a month, longer than 2 days, longer than 1 week, and that is happening now. All we're getting is lip service from the government, and that ought not to be the case.
I have to mention, just in case anybody might be wondering, that you are evidently a victim, like millions of other Zambians, of the lack of electricity. So that explains why you might be a bit in the dark. But thank you so much for being here nonetheless. So I want to continue now by looking at a different angle. Before we get to the issue that was before court today, I want us to also explore the possibility. Do you think that it will offer any solution or an improvement to people's anxiety with cases like this one, high-profile cases that involve people that have a huge following, in the judicial system, allowing these to be broadcast, to the country? Do you think this is a conversation that we should seriously begin to have as a country, and could possibly even be more transparent and avoid any future occurrence of such situations?
Well, this shouldn't even be a conversation, because there's a law that provides for that. All you have to do as a media house is apply to the Chief Justice to be allowed to broadcast, and you will be allowed to broadcast. Perhaps it's just that no one has put it to a test. If it has, no one has been allowed just yet, but it's something worth exploring. And I'll give a challenge to Diamond to make that application and see if we could have court proceedings being broadcast live for the public to benefit. Maybe, just maybe, we may avoid this issue of people assembling at court. Otherwise, what expected is that perhaps the court themselves would have said, okay, since we do not want a lot of people to come, we are going to broadcast this. Maybe that could have helped in this particular situation. But the idea is the people deserve to know. People should have access to information. Even broadcasting of court proceedings, that should be normal in a democracy. It is not a cult, like I keep saying, that those things should be held hidden from everyone else. Cameras should be allowed into the courtroom within permissive limits, of course. And journalists should be allowed, because it's the same thing that is recorded, as you put it in writing, which you can put on video or even audio and transmit for the whole country to benefit.
And I have to say that we have applied before, and hopefully in the near future, it can be granted as permission for us to be able to do this. But let's talk about what happened today itself. The court, ruled that this petition of the eligibility of President Edgar Lungu should be heard, and effectively the argument has been that it's going to be heard now for the third time. But with the wisdom of the court in mind, what do you make of this decision today? That this preliminary hearing, hearing must proceed, and the petition must go ahead, as opposed to former President Edgar Lungu asking the court to throw out this petition.
Okay, let me give you a bit of background to this matter. This will actually not be the third time. This will be the fifth time. The first time was in the matter of Dan Pule and others versus the Attorney General and Edgar Lungu. The second time was Bampika Palasa versus the Attorney General, when he sued for purposes of having a declaration or interpretation of Article 106 to do with the election of a president, and whether a person has been sworn in twice or has held office twice, and what it means to hold office. All those arguments were put in there. Then there was a matter that was commenced by Process Foundation, the Attorney General, and the other one was Sishua and Chapter 1 Foundation versus Edgar Lungu, and except these last two were consolidated and heard as one. So these are four matters. The third was consolidated and heard as one. So this one would be the fourth, or indeed the fifth matter, if we're going to follow with this explanation that this court has to deal with. Now, what had happened was we raised a preliminary issue when Mr. Chizombe sued, and our instructions were that, listen, this matter has been determined 4 times, and this would be the 5th time that this matter is coming up. Having been dealt with this number of times, should we keep going back to court over and over and over again? So we raised that issue and went back to court, in which we argued that the court itself, not once, not twice, 3 times, has had judgments regarding this matter, saying we have exhaustively dealt with this matter. This man is eligible. And those that were content with the fact that he stood or to stand, understood and moved on. Now we had the Minister of Justice then, Mr. Mlambo Haimbe, saying that he was not eligible and that the matter would be taken to court. The next thing we saw was Chizombe going to court, and now we are in court and we've raised these particular issues. So the court, having raised those issues and having argued to say, you have already determined these matters, the other side responded and said, no, there are some things that the court may have forgotten or may in ignorance not have considered that we want this court to consider. But we also responded and said, there's nothing that this court did not consider. Everything was considered. As a matter of fact, the Attorney General, being a person or the custodian of public interest, has been in these matters. Therefore, the interest of this person was already taken care of in these matters. Otherwise, we'd find ourselves in a situation where each and every Zambian goes to court suing the same person for the same thing just because they didn't get their chance in court. The argument by the Attorney General was that, God forbid, but even if it means 20 million times the matter going to court, so be it. That is not the law. The law is that once there's a final determination of a matter, then you cannot proceed to have the matter re-litigated over and over and over and over again, because that's against public policy and matters must be brought to finality. So having raised those, today we're going to court for a ruling. And the court did observe that, okay, you have brought this matter for our determination. We note that what you have raised are the same things that you are dealing with in the main matter. So instead of dealing with it at the preliminary stage, we'll deal with it in the main matter. We'll deal with everything in the main matter. Of course, we are obliged to follow the advice of the court. If you ask me for my personal opinion, I would say that the very reason they have used to deal with the matter on its merits as the main matter is the very reason they should have determined it at preliminary stage, because it is the same things that have been raised for summary and determination that have been raised in the main matter. So that is the approach that we would have hoped we're going to go by. But the court has decided that they will hear the whole matter at some point, meaning that the whole matter has been reopened. Now we have to deal with the issue of whether he's eligible or not. Even with that, arguments are not changing. You have decided this matter already, and therefore, this is the position that we hold. Then the court will determine. We'll leave the determination to the court.
Do you think that, this should be up for discussion at this time, considering the many times that it has been talked about? But I would also like to find out what you are saying with your client and generally with what you think the reasoning behind this being brought up is.
Well, besides the politics that are prevailing now, I don't see any other reason why it is being brought up. But as the is being determined by court, we will only stick to legal arguments that we have. They have their arguments where they're saying that there are some matters that the court may have overlooked. We that you determined everything. There's nothing that you overlooked. The matters have been raised. We are arguing in court that these were already dealt with. And it is now for the court to look at that, whether or not they dealt with everything. If at all they come to a conclusion that there are certain things that they did not deal with, they should deal with those. If they come to a conclusion that they dealt with everything, then they will be able to say, okay, we dealt with everything. So we'll leave that decision to the court. We can only present our argument.
There's a lot of interest, and it's very similar arguments. I was listening earlier on today to the lawyer of the petitioners of this case, and they were clearly saying that one of the things that they bring forward as an argument is the fact that the law cannot be applied in retrospectively. I beg your pardon. And that the 2016 constitution would then apply to those that come after 2016. And anything that happened within the previous constitution must be guided within that context. But this argument, for a lot of laymen, can be a bit confusing. And I would like you to, offer what your thought is with regards to that.
See, the idea is not to argue the case in the media. And in not arguing the case in the media, we are saying that that is the argument that they presented before court. And what we're telling the court is that this is not a new argument. This argument was presented before you, and you refuse this argument. You refuse that argument in the case. You refuse that argument in the Bampika Palasa case. You refuse that argument in the Sishua case, Chapter 1 Foundation and Legal Resources Foundation cases. You refuse all these arguments. Why should they be allowed now? Why should you accept now? The court has to be consistent. We are arguing. The court has to be predictable. We are arguing. And we think that is a hallmark of a good judicial system. Predictability, certainty have to be there. And those are the arguments that we're presenting before court.
Without being prejudicial, to this court case, I'd like to find out, and I think that this is something that a lot of people are asking. If it ever so happened that the court rules otherwise, contrary to what has previously been heard, what would the implication be on the general election that was held in 2021, if any?
See, I wouldn't want to speculate as to what necessarily would happen if they would otherwise. I would be coming up with a conclusion of the court. But all I can say is that in our arguments to the court, we are telling them that even assuming that this matter was right, that's the argument we've taken. We're saying that if any person is going to challenge the nomination of a candidate, they have to do so within 7 days of that candidate filing in their nomination. If they don't do it within 7 days, then the court no longer has jurisdiction to deal with that. So they have gone to court and they're saying he should not have contested that election. They're challenging his having been nominated then. And we have argued to say that they can't challenge his being nominated because Article 2 of our Constitution says that you can only challenge that within 7 days. We are 3 years down the line. If at all it was the election itself that was being challenged, you also challenge it within 7 days. And that was not done. So meaning that the court does not have jurisdiction anymore. So those are the arguments that we presented before court to forestall that. So we don't see a situation where we would be trying to imagine what would happen if they did not do so, when we are arguing that, listen, if at all you're going to make, you don't have jurisdiction because this matter should have been filed within 7 days.
And I get your context, and I'll be very deliberate with the way I move forward from this topic, because I'd like for a lot of people to get the clarity, because I've heard them ask this question. So if effectively, if any other candidate was ineligible to contest the 2021 election, as it were, if any other candidate, doesn't even have to be President Edgar Lungu, if any other candidate was ineligible to contest, based on the provisions of the law at the moment, there's nothing that can happen to that specific election because the time to seek redress has elapsed constitutionally. Is that what I'm hearing you say?
That is what it is. Remember the Mnaile case where Mnaile was declared a winner by me. Then the person who actually won that election went and petitioned that particular election. But because the petition itself was signed by the lawyer and not the petitioner, the court threw out that petition. Now that person had an option to get back to court. Now, the time they were supposed to get to court, they were already out of time. They were already out of time. So they could not challenge that particular wrongful declaration of Aile as a member of it. As such, there was nothing that could be done. And the person went ahead and was a member of parliament for the whole duration, all because the court no longer had jurisdiction. So that is what I'm saying to you.
I know that it's in the interest of time, that it's in the interest of the speedy delivery of justice, especially the nature of elections, that there's a cap onto time, onto when these issues can be presented. But based on that kind of a scenario that you've just highlighted, and possibly even more in the future, should we be, should such be bound by time? Do you think it is necessary for these issues to be bound by time, or we should allow for justice to be served whenever the need arises?
See, I think the idea of having matters time bound has its own purpose that it serves, because you wouldn't want to be in office at any given time fearing a challenge, and each and every person challenging you. You will spend your whole time in court. You will never be able to do anything, because each and every day, every other person will keep challenging that particular decision. That is, if we're going to go in the manner that is being suggested, that matters can keep coming up over and over and over and over again, then there'll never be finality, and public policy really would not be, it would not be in the public interest to do such a thing. So public interest would have to win in this particular matter.
Let's come to our final part of this interview, because it just keeps getting darker and darker.
It's getting darker and darker. We live in tough times.
Very tough times, I've got to agree with you, and I know a lot of people agree, and they will bear with you for sure, because they wouldn't do anything about it either. The final part of my interview with you has got to do with what's going on in the National Assembly at the moment. There's 9 PF members of parliament whose seats were declared vacant by the Speaker of the National Assembly, announced by the second Deputy Speaker. And this puts a lot of people, citizens, constituents in limbo. But it is also true that this is not exactly inevitable, that this couldn't have been avoided. And I want to ask a pretty generic question before I get into the detail. If you're, from your observation, having served as a member of parliament, if the legislature, the present legislature, the present form of the legislature is independent and is showing, traits of being in the interest of the Zambian?
I must state at this particular point that I am acting for the 9 members of parliament. The matter is in court. We are in court tomorrow morning at 08:30. So this matter can be heard. We are appearing in the High Court, and as such, what I may say as regards this matter may be limited. Speaking generally with the legislature, see, it's quite interesting. I remember sometime in November of last year, 2022, when there was a point of order in Parliament by Honorable Taylor, where he sought that Mao Sampa be expelled from their house because he had been expelled from the party. What the ruling was from the Speaker Nelly Muti was that to expel Mao Sampa from the house or to declare the seat vacant would mean that she would be interpreting the Constitution. And she has no such jurisdiction because the court in the Chimbakambili case said they are the only ones that have that jurisdiction. That was the ruling that was there, and we expect that there should be consistency in light of the precedent that was set. Purportedly expelled, they got what has been breached from the Constitution. So we are not going to entertain your matter. Immediately, members of Parliament and file it in court. So it is an active matter that is in court. They go to the National Assembly. The Speaker is notified of the matter pending in court. A point of order is raised. Mao Sampa writes and says, I have withdrawn what I did. The National Assembly ignores the fact that there's a matter that is pending in court to determine whether they were rightfully expelled or not, and goes ahead and gives that ruling nullifying the seats or indeed declaring the seats vacant. That is the matter that has gone to court. And those are the circumstances under which the issues have arisen. And one would wonder, okay, why is it that when it came to Mao Sampa, you say we have no right, because to do so would mean we first have to interpret the Constitution. And in this particular case, they're saying, yeah, we can go ahead and do so. So that is the argument, or part of the argument that has been taken to court to say, look at what has happened. There was this issue that happened. The matter wasn't even before court, but the Speaker said, I have no jurisdiction. Look at this matter. We are in court challenging the expulsion, and no court has confirmed our expulsion, and yet we are being sent out of the house. Is this okay? So we'll wait for the court to tell us whether that's okay.
Finally, isn't this quite telling about the political landscape in the country? And I'm not just going to make reference to the Patriotic Front. We've seen this before with the with the Movement for Multi-Party Democracy, the MMD, very similar maneuvers, you know, of how the political party found itself in the present leadership. And at some point, another form of leadership of the MMD, the Patriotic Front itself, has been here before. You know, this was this kind of factionalism was there in 2015, and should it really be difficult to identify who a leader of a political party is, a legitimate leader of a political party is, to the extent that even the National Assembly is confused on who the leader is, the Registrar of Society doesn't understand who, the country doesn't know who the leader of a political party is? Should it really be this difficult in a democracy like Zambia?
Okay, I'll tell you this. It is not difficult to tell who the leader of the Patriotic Front is at this moment. The judiciary knows. The executive knows. The registrar society knows. The legislature knows. The only thing that is happening is that there has been conspiracy to kill the legitimate Patriotic Front. It is known where the numbers lie. It is known who's holding the party together. All that is known. As regards the leadership, no one doesn't know the circumstances that led to Mao Sampa claiming that he's a leader. It doesn't take rocket science to know what exactly has been going on. The executive has played a role in this, and they have perpetuated an illegality, and they know it.
Except
something that is not known by anyone. No one can pretend.
Except there's just no way to qualify it, isn't it? I mean, it's only something that you can say, but there's no way to qualify it.
There is every way to qualify this.
How do you qualify
No one in their right senses would say that what happened was the right thing to happen. Not even you, Uyoya.
But just because it's not the right thing doesn't mean that the executive has something to do with it.
Well, just because the executive claims not to have something to do with it does not mean that they had nothing to do with it.
So then how do we qualify it? I think that's the argument.
Qualify it in the sense that the so-called conference was held in the night. And in the night itself, the IG, the Inspector General of Police, went ahead and purported to clear fingerprints in the night on a public holiday, the 24th of October. Who does that in the night? No one does that in the night, unless you're complicit. We went to the registrar societies, applied that we be given the that was there. We that was there, and it showed that bearers had not changed of the 3rd of November last year. All that being there, what has happened, the Registrar Society was moved only for the reason that we were given the register as of November. And not that we did not follow procedure, we paid for it. We did not just pay for it, we also got a court order for it. I had an interview with you. And with all that, the punishment went to the Registrar of Societies. And this time around, the Registrar of Societies is still at home, suspended, getting paid for doing nothing. And yet she's supposed to be holding that office. So you can see that there's the fingerprints of this government everywhere, complicit in an illegality that is being perpetuated in the Patriotic Front Party.
Well, thank you so much for your contribution.
That is what every person should be able to think of and say that these guys are complicit in this matter.
Thank you so much for contributing to tonight's edition of This Day. We will have to conclude our interview here, and we wish you electricity anytime soon. Possibly not, but hopefully you may have electricity soon.
I'm sure within the next 48 hours or more, we should have electricity.
Well, I don't think 48 hours, but thank you so much for talking to us on this edition of This Day.
We'll buy candles.
Thank you for talking to us.
Thanks for having me, Boyare.